to John and Municipal Coordinator Duarte. And I will call the meeting to order and put forward a motion to adopt the agenda. Can I have a second through a hand or an aye? Thank you. Any changes, amendments, CAO? I don't think you have any. No. Councillors, any? No. Good. Call for the approval of the agenda as put forward. I'll confirm that with yes. Please advise if you don't agree. Carried. Thank you. Public participation. I think we have one person in the public in the gallery. If you wish to unmute, you can come on for 2 minutes. If you don't, we'll let you watch your name staying silent for 10 seconds and we'll move on. Thank you very much. We'll move on. That'll conclude public participation. Item number 4 is review and approval of minutes of prior meetings. And for the councillors, I'm sure you'll hearken back just like it was yesterday to March 30th. And I'll put forward the motion that the CSC meeting minutes of March 30th, 2021 be approved as circulated. Can I have a second, please? Thank you. And to those of you who would like to make some changes, this is your opportunity, just like it was yesterday. I'm going to presume there being none. I'll call a motion that the minutes are accepted as provided before us. All those in favor, yes. Those opposed, no.
Yes.
Yeah.
Okay, thank you. Business arising. I'm going to speculate there is none from my perspective. This is pretty stale stuff now. Anybody else? Nope. Okay. Then we're off to the reason we're here tonight. And CAO, a little bit of help here. It's been a long time since we did a CSC. This is not a decision-making meeting. So the objective is, how do we end this? To send you away with direction?
Well, it depends. If you have a clear takeaway at the end of the meeting, then you would perhaps want to recommend to yourselves, i.e. recommend to council that council take a particular course of action. Alternatively, you can direct that staff provide further information. There's a couple of outstanding items that I don't have all the information on yet, such as the risk assessments and such, but we can get to that.
Okay, thank you very much. 15 seconds. This is the 5th time we've looked at this over many, many months. I think the information is substantially here. And at our last regular council meeting, there was a takeaway for the CAO. Shall we start there?
Sure, we can start with that.
Let's start. So let's just refresh on what was left and then circle back. And I'm going to go next to you, Councillor Barmeyer, if that's fine, if you've got any thoughts or where you want us to go. And we'll start there and then we'll work through the lead chain, if that's fine with you.
Well, perhaps before you go to Councillor Barmeyer, I could just update you in terms of...
you first and then...
okay, go ahead. So I did get back an email today from one of the MIA BC people with respect to costs. If council elected to proceed with service provider agreements for, there was the parent and taught group, the volleyball and the badminton, each of which would be $250 if you chose to go that route. There was also a request, and it's a different person who's been away. She just got back, and I'll be talking to her tomorrow. She's the one in charge of the risk assessments. And so the idea is to have risk assessments done for the parent and taught group, the yoga group, possibly music together, and arts and crafts, quilting, et cetera, et cetera. The idea being whether or not those activities actually need to have any insurance at all, whether it's mandated or not, they would still, I think, be in a position of opting for insurance if they so chose. So that's yet to come. So there's a bit of a dangling string with respect to that aspect of the options that were listed at the end of the presentation, which appears on page 51 of 55 of your packages this evening. So just sort of in that vein, the additional improvements to option 1 that were added for this meeting include softening the rental agreements, release waiver and indemnity provisions to be more even-handed, limit the indemnification to the amount of insurance coverage, and provide for mutual indemnification regarding municipal liability. So those were put together as a result of and after speaking with the person at MIABC who addresses the legal side of things for them and how their programs are put together, the pros and cons and ins and outs of things. I had asked some pointed questions to her, sort of along the lines of, you know, if council chose to not require anyone to have any insurance and nobody had to sign any releases or indemnifications or waivers or anything like that, would that affect the municipality's premiums for its insurance coverage? And the answer was basically no. The way in which premiums are set is based upon population and then your experience. So if you have had any claims over the amount of your deductible, for us, that amount is $2,500. So if there's any claims over $2,500, then your experience rating is affected in a negative way, and that will affect your premium. Her comment was, however, that if you chose to have no insurance and no releases or waivers or indemnities, then you know, the chance of having claims over and above that amount may very well be increased. So ultimately an increased risk of future increases to our overall premium under our umbrella coverage. We talked a bit about some of the nuances of the service provider agreements. In particular, the requirement under those agreements that the service provider agrees to indemnify, defend, and hold harmless the local government, et cetera, as a result of any claims that are a result of the provision of the services that are outlined in the agreement. So they are required to indemnify the village if they are to be covered under a service provider agreement. There's no ifs, ands, or buts about that. However, that indemnification is limited to exclude such liability, loss, or damage which is the result of or arising out of the sole negligence of the local government. So if we're liable so if the person is injured because of our fault, then the service provider is not liable under that clause, or that is covered by the MIABC liability insurance policy. So in other words, indemnification up to the amount of $5 million would never be called upon because they're covered up to $5 million. So beyond that, they would have an exposure. However, the discussion that I had with her was along the lines that, you know, whether it's 5 million or whether it's 2 million, there's a good chance that the MIABC would, in discussions with the municipality, if the municipality so chose, agree to waive indemnification from the individual residents over and above the amount of any insurance. So if the insurance is paying for $2 million and there's a claim or an award of $3 million, then there's an exposure of $1 million and an indemnification exposure to us by the resident for that $1 million. However, if the village didn't want to collect from the resident, then for that indemnification, and presumably our insurance cover that balance, then they would likely, she said, agree to not pursue the indemnification against the resident. So, yeah, I mean, because that, and the reason then why that is in their control is because our insurance policy, like all insurance policies, for the most part, provides that the insurer is subrogated to the claims of the insured. So what that means is that they stand in our shoes when a claim is made. So when somebody claims, they claim against, for example, the Village of Lions Bay, but the MIABC stands in our shoes as the Village of Lions Bay and defends that action and pays out in accordance with the policy. The litigant doesn't sue the insurer, for example, but it means that whatever avenues that a party has for recovery, the insurer is able to stand legally in the shoes of us and pursue that avenue for recovery. That's why it's up to them to decide whether or not they would pursue any avenue such as indemnification that existed. The other reason that she said is important to consider with respect to an indemnification clause is that when there is insurance, the first thing the insurer looks at is the contract, so the rental contract in this case. And if there is an indemnification clause, then they cover the defense entirely. So our insurer is not required to step in. They would be kept abreast and so forth, but they wouldn't be incurring the primary costs. The independent insurance company that we provide for, they would be in that position and defending the action entirely on our account as well, because of the fact that there's an indemnification clause that their client, the insured resident, has an obligation to repay us any amounts that we are out of pocket on account of that person's liability. So if there is no indemnification clause, then the insurance company does not take that onus upon themselves, and our insurer has to step up to the plate and defend our interests as well, for which they will incur costs and which will affect our insurance premium. So there are reasons why it's prudent and effective and important to have indemnification clauses. After a lot of discussion and my questions about limiting that indemnification, she said, yes, you can, instead of leaving it to the MIABC to decide whether or not they would waive pursuit of an indemnification over and above the amount of the insurance, we could provide, as I've done in the draft amendments to the rental application form, we could provide to limit that indemnification that they sign on to the amount of the insurance so that they're not exposed for any overage. And so we can do that. It doesn't affect our premium. It just takes that issue into our own control. We're not left to have a discussion with the MIA about not pursuing our resident for any overage in terms of liability. So those options that are listed on the last page in terms of improvements to option one are with a view to maintaining a more moderate and quote unquote fair provisions for release, waiver of liability, and indemnification that I've set out in the draft amendments, and to limit the indemnification obligations of the renter to the amount of the insurance. So the insurance component is an important aspect to maintain. And as I've remarked throughout the materials and in the presentation, is something that works remarkably well, hasn't created any issues, is cheap, convenient, and keeps the control of the insurance and people's ability to cover themselves for what they're undertaking within their own sphere of authority. They have the ability to control that. If they're not comfortable with 2 million, they can opt to take out more if they want, but they have to take out at least 2 million. And that also pushes risk away from the municipality. It puts it on a different insurer, and thereby protects municipalities' own taxpayers who are otherwise on the hook for our costs if they increase, or in the event that something wasn't covered at all. So it seemed to make the most sense to continue with a program of insurance for the 2 million. There may be, as I say, some activities that are so low risk that we wouldn't insist that they get it. But at the same time, if they don't have it, they're still agreeing to indemnify the municipality. However, that indemnification is limited by the amount of insurance. So if the amount of insurance is nothing, then their indemnification obligation is nothing, but they are waiving in terms of liability as against the municipality, except to the extent of our own liability and negligence. Overall, for the convenience and the cost, I think that probably the best option is to continue as we have been, but with the amendments that I've suggested to the agreement. And that provides the most safety and coverage for the resident renter as well, or non-resident renter for that matter. Final comment, I guess, would be also keep in mind that if people rent the hall and they have their own insurance, like the Arts Council or potentially the Stratas across the street, then they can utilize their own insurance. They don't have to buy insurance. They just have to add us as a name insured. And the Arts Council does that on a regular basis.
Thank you very much, CAO. So in brief, option number one is your recommendation with amendments and the consideration of low risk activities that they can opt out. Is that correct?
Yeah, and whether or not council thinks that activities like volleyball or badminton ought to be quote unquote municipal services, that the organizers would essentially become service providers to provide that service is up to you. However, my suggestion would be that the insurance provision as it currently stands works very well and would probably be the better way to go.
Thank you very much, CEO. Councillor Barnier, I know you've got your eye on the clock. I do too. Did you like what you heard? Do you have some suggestions or any questions?
Yeah, no, I appreciate all the work that went into this, Peter. I'm going to need some time to read through this. I'm not sure if I'm in a position to, you know, completely adopt the staff recommendation at this point, because I do think there's some opportunity to qualify certain activities as low enough risk that they don't need any insurance. So I do think that risk assessment exercise is worthwhile for us. I do appreciate the idea that we can, with the first option, limit people's exposure, and I like that concept. I think that's worth exploring. And I do think there are some activities that would fall under our SPAs, and we just need to think that through a bit more. So I know we're trying to stay with the status quo and some minor adjustments, but my concern is more about the perception of volunteers who see that and feel more, feel kind of intimidated by the idea, and maybe not fully grasping the concept of this coverage, because it is a little bit hard to follow, to be honest. It is kind of complicated to get your head around. So I worry about that threshold for new or willing volunteers who just kind of feel intimidated by the concept. So if there were some activities that didn't need any coverage, I think we should just keep an eye on those. And that's really all I have to say at this point.
Okay, I'm just going left to right. Councillor Bain, any comments, thoughts?
Yeah, pardon me if I'm rehashing it just so I can understand it in sort of a few things. Option one, existing insurance program, and it could have the opportunity to have the insurance for a service provider supported through a municipal grant. Is that correct then? Because I thought somewhere in here it said that we can't pay for the insurance for them because that's against the law. But if we give them a grant with the idea that it would cover the insurance, are we riding two horses at once?
Well, the service provider agreements don't fall under option one. That's option three. Considering whether or not to add additional service provider agreements for certain groups, over and above the three that we currently have. Option one was continue with the existing insurance program, and then subject to the amendments that I've suggested in terms of limiting liability or indemnification to the amount of insurance. The concept of providing further support through municipal grant program, I think was geared toward the notion that if renting the hall is not an economically feasible prospect, then council could consider municipal grants for groups that want to do that activity. But I think you're right in terms of, and I think I probably need to get a little bit of clarification to ensure that we're not just stepping offside by offering a municipal grant and having that deemed to be providing indemnification or insurance, paying for somebody's insurance. So that's a good point. It's something I hadn't actually thought about for a while. So something that bears further clarification, I think. Thank you.
Anything else, Councillor Bain?
Yeah, well, that was great. Thanks. I was scratching my head over that one. I have a comment about the rental application form. Do you want to address that later, or should I ask now?
Ask away.
Go away. Go for it.
Well, the thing I'm concerned about it is it's kind of tiny print on my screen. Sorry if I can find it, but it still looks like we've got this thing on it that if there is somebody renting the facilities and everything, they're liable, even with their heirs and whatnot. And I really feel uncomfortable about it. It's to me, it's like the next of kin would be like co-signers, even though they they haven't signed anything. And I don't see how a person commit their next generation to something that generation has not had an opportunity to agree with. It just doesn't smell right to me for some reason.
It's not a contract with one's heirs. It's a contract with the person,
Right.
and the person is the one who makes the promise or makes the commitment as to what they're agreeing to. And if they pass away, then it's their estate that has that commitment, not the heirs. So it's just, this is legal language that has been around for probably centuries, that I'm loath to start playing with. So it's, yeah.
Okay, but you don't feel like this is scaring away possible renters? I remember the Moms and Tots gal said her lawyer advised not signing it, and I was wondering if that's excuse me, if that is where it's originated.
Well, I think that the form as it previously, or as it currently exists, I guess, requires indemnification, which is unlimited. So I think that she got legal advice that she was looking at an unlimited indemnification obligation or liability that she could potentially be facing, and that did she really want to do that? So trying to address that by way of limiting that indemnification obligation to the amount of the insurance, so that renters, residents especially, are covered either by the insurance or not facing further obligation to the municipality over and above what the insurance covers.
Oh, okay, good, thanks.
Thank you very much, Councillor Abbott, and then Councillor Cunliffe.
Okay, thanks, Peter. I'm going to start off by saying, I think by the nature of it, I might be asking the same questions in different ways, but I'm also just trying to make sure I completely understand it. So humor me if you feel like you're answering the same question twice. So just to clear something up completely, if someone chooses to apply for a grant, currently we have 3 groups that have a grant, and therefore, and as part of that, they have an SPA.
So
if a future organization that's not part of that group chose to ask for a grant, be it for the whole rental, or they're asking for a grant of in kind, I guess they're not asking for any money, just an in kind thing, that would automatically trigger the need for them to have an SPA, unless the risk is so low, the municipality decides you don't need insurance, in which case, I guess they're not actually.
No, they would still sign. They would still sign the rental application. They would still sign the rental application form. They just wouldn't have to pay the $25 a month for the activity.
Right.
So we already do that with, for example, the seniors.
Right. And then, but in the seniors case, we do take additional riders on insurance for that.
Separately covered, yeah.
Yeah, we cover that separately. But if it was another group, be it a very low risk group, we might not need that, in which case there's nothing. And if it's one of the higher risk groups like contact sport, like volleyball, I guess, well, it's not quite contact, but I guess maybe it is, then we'd probably then be looking at going to get an additional SPA rider, correct?
You wouldn't necessarily have to have an SPA. To Fred's point, I think I need to clarify, what we can and can't do in this respect regarding municipal grants. But I don't think, like if you had, let's say you had a grant for the volleyball group, and Well, that was a question that I was going to have to explore. But you mentioned something about if there was a group that was of such low risk that there was no insurance requirement. So if there was no insurance requirement, but they would still need to sign the rental agreement. The rental agreement would stipulate that their obligation to indemnify is limited to the amount of the insurance, which we have specified as 0. Mm-hmm. So their obligation to indemnify is 0. So the municipality is taking on the risk entirely that if something happens, somebody, we're going to get named in any lawsuit anyways, but we would definitely be the ones that would be on the hook. And the ones, because of something to keep in mind is joint and several liability. So if let's say a renter is, say, 60% liable for the injuries that somebody sustained, and the municipality is 40% liable, joint and several liability says that the plaintiff can collect off of either party up to the full amount. So they don't have to get 60 from the resident and 40 from us. They can collect up to 100% from one party or the other. And generally those kinds of arrangements get worked out between insurers. But yeah, joint and several liability is also something to keep in mind. But I don't think it would really affect anything in terms of the resident group that is not having to purchase insurance. If they choose not to purchase insurance and they get sued because of something that happened, then they're in a spot where they haven't taken out insurance. So that's why subject to the MIABC risk assessments that we get and subject to council's own view as to risk and what you want to take on or not, why it's likely best to always require the insurance. Those got that third-party insurance that's going to cover the first $2 million. And it puts the renter in a much better position, because I don't know that I'd want to be a renter and face an action for somebody who got injured during the activity that I organized, and I didn't take out insurance. And now I'm left hoping that the municipality is going to pay for everything. And probably that's how it would end up, but it wouldn't be a fun time.
Right. Okay. I think you've cleared that part up for me, but I'm still not 100% sure. Let's talk about for the lack of a better one, call it the senior circle at the moment. So they have an SPA.
Sorry, which group?
The seniors.
Okay.
Seniors.
Yeah.
They have an SPA. They tend to have one main event at the moment being Tai Chi, but in the past they've had various different events. Sometimes organized by different people. Typically, maybe it's the same couple of people each time. Does someone actually sign the rental agreement each time they put on a separate event, or do they sign the rental agreement once a year?
It's usually once a season, like September or January.
Okay. And so whoever's signing that is potentially taking some liability on themselves, or are they somehow held harmless by the fact that we have an SPA? That's the part I'm trying to hold up.
They'd be covered by the SPA up to $5 million. But so in the course of discussing best practices for using SPAs, it was suggested that it would be a good idea to have every member of the group sign the service provider agreement, because that just make sure, and you know, notwithstanding the difficulties sometimes with people coming and going from a group, it's nonetheless just something that the MIABC encourages that clients do. So that was a practice that we're going to have to look at implementing.
Okay.
Are you good for now, Ken? Are you
Yeah,
good for now, Councillor Babbitt?
Yeah, let me just look. Sorry, let me have a look at my other notes to see, because I think we might have gone slightly different track than I was thinking. Okay, so I think you've answered the one. If there is no insurance, we decide at such low risk there's no insurance, where does that leave the organizer or the instructor for that matter? And it leaves them in a personal risk situation. You answered that. Okay, so I answered that. Then I want to get their own insurance. So on options, on your option number 2, you've answered that question as well. Okay. Now option number 3, that's the SPA one. Okay. I think this Recreation and Culture Service Department, or whatever you want to call it, I think none of us are going there, so we can ignore that one. I do like the fact that we've softened, yes, that's the right word, the release, and I do think that particular part of it was, in my mind, probably the biggest issue for everyone, including Riley Dahl when she wanted to do the TOTS thing. I did ask her about that and she confirmed that. It was less about insurance or cost insurance or how to get it. It was about that. That holding harm was part of it.
And just to clarify, at the time that she was trying to set it up, that particular activity had fallen between the cracks from transferring from one insurance company to another through the insurance portal. So that was corrected, and the cost and the ability to sign up is now rectified and is easy and cheap.
Yeah, she confirmed that when I had the discussion with her. I think things have moved on and she's not able to do it for other reasons. But even once that had happened, she was still concerned about the rental agreement and the language there and holding the village liable. And then Lloyd told her that was back to front. They should be holding me liable. So anyway, and I think that's kind of where most people, when they started to read and become aware of this, got concerned around that part. So I think softening that sounds good. It does seem a little, it seems like it wouldn't be wise, even once it's softened as you describe it, to then go in without insurance, because there's still the personal liability part that someone may decide your negligence caused the issue. So I think I've kind of got that clear in my mind. Okay. And then on point C for additional improvements, provide for mutual indemnification re municipal liability. Can you expand that one in a few more words, just to make sure I understand that, because that one still seems a little bit unclear for me.
So that would be in clause 3 of the amendments to the rental application form.
Right.
So what it's saying is that they agree to hold harmless, indemnify, etc., except to the extent that we are negligent or willfully misconduct or misconduct ourselves, and only up to the amount of the insurance coverage in place, in exchange for the municipality agreeing to hold them harmless and indemnify them from any and all liability for any such damages attributable in law to the municipality. So we can indemnify them against any liability for which we are in law responsible. We can't indemnify them for their own liability, which is the point that was being made in the legal opinion. So that was specifying and clarifying for us that we can't indemnify someone against their own liability. That is essentially contrary to the Financial Institutions Act because it constitutes the provision of insurance. So what we can do is they agree to indemnify us for their liability. We agree to indemnify them for our liability. That's what a mutual indemnification clause is all about. And that's what I've implemented here as a suggestion.
Okay.
Councillor
Yes,
Abbott.
sorry, I have one last question, and I think I'll be clear after this. So can you just remind me, you mentioned 3 groups that have SPAs: Trailblazers, Seniors, and
Events Committee.
Events Committee.
Events Committee.
Events Committee. Okay.
Which is not really a committee, but a group.
Group, but it's the service provision thing. It's a definition of it, actually.
Yeah.
So your idea that everyone should sign the rental agreement. What happens in an events committee event? You're not going to have everyone that walks in the door sign it, right?
Yeah, I mean, it really, at the end of the day, it comes down to establishing who's part of the group that for whom or for which insurance is being provided. So it's a case of establishing that as a matter of fact and in law. It's just a lot easier to establish if everybody signed it. So it's really just, it's a best practice. It's not a necessity. You can still have coverage without having signed it.
There you go.
If you're part of that group.
Thank you very much, CEO.
Part of the people, sorry, Ron, I will try to keep this going fast. Part of the group that attends the event is what I'm saying, as opposed to the group that organizes.
Sorry, the group that is attending the event?
So when
it's not providing.
So when Councillor Abbott and I attend a events committee, that's not the same thing.
Sorry,
we're not providing a service.
When you attend what?
One of their events. No,
you're just attending an event. They are the ones who are providing the service. They're setting up the event. They're organizing it. They're putting it on.
So everyone that's part of the committee that organizes would sign on to it.
Yeah.
Yeah.
Okay. So then going back to a Tai Chi type event, then it's only the organizers you're talking about. You're not talking about everyone that attends the event. They're either signing on.
No, not necessarily the participants, but the organizers who may in law be responsible for something that happens.
Okay. And I guess there's just one last thing that comes to mind here, and maybe it's just for council to think about. Is there somehow a sort of equity issue here of those that are more organized and have a grant versus those that do things more ad hoc and use the hall? And does this drive us to everyone lining up and asking for a grant next year? I'm not sure where that ends, or that I guess to me that sounds like a possibility that we need to just consider. And what do we think if that's the way it goes?
Yeah, I mean the hall rental fees are set with the principle of cost coverage, not profit. We were able to reduce the cost of hall rental fees when we implemented the online insurance program. Dropped from $40 to $25 because it was less expensive and we weren't involved in the insurance process, which we shouldn't have been to begin with. But yeah, it's not an expensive proposition to begin with. So not sure that the municipal grant idea is necessarily something that ought to be pursued, because like you say, how do you distinguish one from the next? And might as well just say it's all free, which is difficult as well. So,
yeah, but my equity issue was more about how they covered under the insurance rather than the actual cost of the $25. But okay, all right. I guess Norm's probably left or leaving.
Thank you. Thank you, Councillor Abbott. And I wasn't rushing you. I had my eye on the clock for Councillor Barmeyer so that he'd have last words, but he's already left. So I think if you're done, then I'll go to Councillor Cunliffe and I'll close this. Are you good?
Yeah.
Thank you very much. Councillor Cunliffe, anything you want to add to what's been said?
Other than it seems very complicated. I guess my suggestion is that I do like the idea of looking at activities that are of low risk that could be considered provided by the municipality. Drop-in volleyball, badminton don't seem at high risk, but I'm trying to wrap my head around how I can go and purchase a day ticket for Whistler Blackcomb, and by merely putting that ticket on my jacket, I have given up any right to sue the mountain outside of some sort of extreme scenario. Like I was working for Whistler when the Quicksilver chair had its pile up, and that was just a whole other thing outside of drilling yourself into a tree while you're skiing or getting hit by another person on the hill. So is there not a simple solution where you want to come into drop-in volleyball, you sign a waiver, I take responsibility for myself tonight, and if something was to happen, I'm bringing my child to the top drop-in program. If they fall and break their tooth, that's my responsibility. I brought them here. I guess that's what I'm trying to understand, is if there's not just a more simple solution like that.
Yeah, I think that, you know, at the beginning of when you started speaking, though, I wanted to clarify that, you know, when we're looking at activities that are of such low risk that they don't need insurance, they're not municipal services. They're just activities that people want to do that are of low risk and don't need insurance. Municipal activities would require a service provider agreement. So you don't have to have a service provider agreement with volleyball. You could say, I mean, I don't think that risk assessment is going to come back and say volleyball is of such low risk that they shouldn't have insurance, because volleyball is probably, of all the activities in the hall, the riskiest on, you know, comparatively speaking to the rest. But yeah, you could have something whereby if you choose, you don't have to have insurance to come into the hall and play volleyball. But yeah, you've signed, you know, whoever's organized it is the problem. Whoever's organized it has signed the rental agreement to say that essentially that, you know, they're renting the facility on behalf of the group, and they're waiving liability and taking it upon themselves, et cetera, et cetera. So whether or not you want to encourage that person to take out insurance by saying thou shalt take out insurance is something that, you know, you want to consider in the big scheme of things. I think for something like volleyball, it really ought to have insurance, a minimum amount of insurance of $2 million, or alternatively, if you want to say, we're going to cover this group as a municipal service that we would put on if we had a recreation department, and because we don't, we want to hire Mr. Smith to organize and put on this service and to provide this service of volleyball on Tuesday nights, whatever it is. And then you pay the $250 to MIABC, and they're covered under that agreement up to $5 million. There
you go. Councillor Cunliffe, any more questions?
No, that sounds like a more simple solution. So I would say looking at categorizing which activities are low risk and really don't need any insurance, as opposed to the ones that we could classify as municipal services being provided for $250, seems to me like probably the easiest way around this, with the option for the renter to always take out extra insurance if that's their particular comfort level. And is there any hope in perhaps looking at the language around the rental agreement? Just, is there an option A and an option B, depending on the liability that each renter may be taking on personally?
I think that the wording of the rental agreement I would suggest that it be amended in the manner that I've put forth. But I don't think that you would distinguish the wording that is there for groups that do or don't have insurance. The wording is such that if they do have insurance, they're covered up to the amount of the insurance, and their liability is limited after that, as far as the municipality is concerned. And if they don't have insurance, then it's a little bit different. But
Okay.
yeah, you'd have this or something entirely different. But I think this is the way in which it can be amended to best protect both the renter and the village, and to make it reasonable in terms of how that's treated.
Thank you very much, CIO. Last call, Councillor Cunliffe. Otherwise, I'll close on the horn here.
No, good. Thank you very much. Thanks for that, Peter.
Thank you very much, councillors. CAO, I played volleyball for the last 3 years before the pandemic arose, and we started closing things in March. I will tell you, it is a blood sport. There is blood every game. And some people leave when fingers should be going north, but they're south. And it is high risk. I understand that, and the same tradition that older people play, even older than I am, play badminton, and they view their game the same. So I'm all for what seems like obvious yoga, crafts, quilting, caroling, pretty low. I mean, I suppose somebody could trip on a crayon on the floor and things like that, but it's low. So I guess on the two things here on the options, which is number one, with the enhanced programs that you've come forward with, I like that. And I think that's echoed with the councillors. Number two is to identify the low risks, and also the opt-in. The last one, back to the volleyball for a second. Within the volleyball crew, as an example, clearly there were, I can think of a couple legitimate SPAs who played college volleyball for 4 years. They're qualified, they're instructors as well too. It kind of fits more in the flavor of it versus getting around it. So something for you to think about.
Sorry, can you expand?
Well, there's an instructional element to it, and they're qualified to do that. So it's like I think that's part of the piece of being an SPA.
Coaching is what you're suggesting.
Sorry?
If we're going to have if they're going to operate on behalf of the village, then there's a skill and educational component to that, which they're providing as well too.
Yeah, I mean,
as well as the organization.
Yeah.
So it's a legit deal in my view, and I'm sure that would be the case if we went to some of the other ones. So I will hand it back to everybody for one last call, but if I've kind of got the editorial here, is that, and I'm trying to close this in here, is that council appreciates the discussion and that off the options number one with all of the additions to that to be explored, and option number two, which is the minimizing the risk or the risk-free ones, if that could be quantified. And I think you had a couple of takeaways that you wanted to explore a little bit further.
Yeah.
So that would be, I'm going to put it to council that is our recommendation for you as to the course of action. I know our council meeting is next Tuesday. It's probably premature to bring this back at that time. That would be a nod, I hope.
Probably, but I'll see what happens tomorrow when I talk to
Okay,
you.
so that'll be a maybe back on Tuesday, and that'll be a maybe back on Tuesday, if not the meeting after.
Yeah, I mean, I could give you an update orally if I don't have.
Okay,
let's where things are.
Let's go with the oral update then, and then if you want to finalize it so we get down to the pretty final stuff. Okay, councillors, if that sits well with you, then, and I'll say, are you fine with that recommendation that I've made to the CAO on our behalf? So, Councillor Banny, you good with that?
Yeah, sounds good. I appreciate a little more clarity coming in And just one other note to yours, Ron. About 35 years ago, I played volleyball there too. Came down from blocking a shot and ended up with an evulsive ankle fracture and sprain. So your point about the blood sport is well taken. Thanks.
Thank you. Thank you very much. Councillor Abbott, are you good with the recommendation?
Yeah, I'm good with it.
Thank you very much. Councillor Cunliffe, are you good with the recommendation?
I am, and I would just like to comment, I appreciate how you and Neville coordinated your outfits tonight.
With cameras on, we visited the closet.
It's my brother and my brother, you know. Okay, thank you very much, Councillor Cunliffe. You're getting to be a little funmeister in the early evening. There you go. Okay, I think so. CAO, you've got your direction. Thank you very much. Let's close out on the reports. The mayor has none. Council members, it's the time for anything you want to talk about for a minute. Otherwise, we'll move on. Nope. Good. Committees, anything? Actually, I'll just quick update. I think many of the councillors were at the 50th and the CATSEM celebration on Friday. Hearty stock all, about 60 folks there. And I think that will probably be the 50th last meeting or event that they're doing. So that's my news. New business, hard to find new business in a CSC, isn't it?
Mostly, yeah.
Mostly it's impossible. Okay, public questions, and we still have one member of the public on. So if you'd like to unmute and come live, we'll ask you to do so. Thank you very much for joining in the gallery, and I'll put forward the motion to adjourn. Can I have a second, please? All those in favor, please confirm by saying yes. Those opposed, no.
Yes.
Yes.
Okay. Thank you, everybody. Meeting's closed, and we'll sign off. Have a nice evening.
Have a great evening.
Bye.
Thank you.
Thanks.